The U.S. Supreme Court is about to rule that you have to allow an invasion. Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. Today, ladies and gentlemen, we're going to give a lecture on the recent Trump versus Barbara oral arguments hearing that took place in the U.S. Supreme Court. Right now, discussing the very controversial topic of birthright citizenship. So we're going to go over the four main arguments. I wanted to go through the full transcript, but it's about 162 pages. If you want me to do a full, thorough inspection of the transcript, a total dissection of whatever they were arguing throughout this oral argument, just let me know down in the comments. Maybe we could do a live stream where we listen to the oral arguments and I can interject from time to time to address the analyses and the brilliance of all of these American Bar Association lawyers and judges. Just let me know if you prefer that down in the comments. But within this lecture, we're going to be addressing the three or four main arguments that are being used by both sides, both the Solicitor General's side and Miss Wang, if I remember her name correctly, who's representing Barbara, and what the justices also allude to. So the first, probably foundational argument of this entire case is a reliance on the 14th Amendment and what it states. Now, we can go about providing the legal analysis, the declared conclusions that the legislators had whenever they went about drafting and implementing the 14th Amendment, but we don't even have to go that far. Why? Because as we addressed in the Addressing the Supremacy Clause and 14th Amendment lecture, which I'll leave a link in the description for you to go view at your own pleasure, at your own desire, the 14th Amendment was never constitutionally ratified, and that's not a personal belief of the Calhoun School of Law. That's not Crazy Caleb up on his soapbox again. That's a formal recognition, acknowledgement by a federal officer, the Solicitor General in 1913, when he said the 14th Amendment and the 15th Amendment, whenever the state legislators sent back the proposals, had rewordings, sentence restructures, misspellings, faulty demarcations, all of these different errors that would render those submissions from the state legislatures as non-compliant with Article 5 to the U.S. Constitution. And if you're not familiar with Article 5, that's the article in the U.S. Constitution that provides the procedure for amending the U.S. Constitution. So he openly admits in his memorandum of law, or his memorandum on the ratification of the 16th Amendment, that's openly, freely, and publicly available online, he openly admits the 14th and 15th Amendments were not ratified constitutionally. He says, but because they broke the rules and got away with it, we can do the same thing with the 16th Amendment. No. And I'm not going to buy the bogus argument that, well, in those times with the 13th, 14th, and 15th, it was just so difficult to perfectly copy everything because there was printing errors, there was a lack of technology. That's totally bogus because they were able to do it just fine and perfectly well with Articles 1 through 10 in the Bill of Rights and then Amendments 11 and 12. So if they could do it then, they could have done it for Amendments 13, 14, 15, and definitely the 16th Amendments. So not going to buy that argument. So just at the start, prima facie, on its face, both sides of this argument, including the support from the U.S. Supreme Court, falls because the 14th Amendment isn't constitutional. Thus, it's not binding. The second argument they allude to is something known as jus soli. And jus soli is an English common law adage. It's Latin, but it's an English common law adage that was directly defined in what is called Calvin's case in 1609. There's a couple points to make on this. One, English common law is non-binding and non-authoritative in U.S. courts. That was declared when the Continental Congress adopted the U.S. Declaration of Independence and sent it off to the Crown. So these 17 times that English common law is alluded to and referenced during these oral arguments should fall on deaf ears, because in case the court and these supposed attorneys have forgotten, we left that system. English common law is no longer binding on the laws or the courts of the states or the U.S. courts, the union courts. So you can allude and cite to them all you want. It's non-binding. And most would say it's not even persuasive. What jus soli directly translates to is jurisdiction by soil. So wherever you're born, whatever government has power over that soil, you are now a subject of. There should already be bells going off big time in your mind. What is probably the most recited line of the U.S. Declaration of Independence? Well, it's okay if your memory's not serving you too well. I've got the U.S. Declaration of Independence pulled up and ready for you. Tell me, ladies and gentlemen, where do the just powers come from? The just powers of government come from? Does it come from upon your birth you're an immediate subject? Oh. It says here that to secure these rights, governments are instituted among men, deriving their just powers from what? The consent of the governed. You, as a newborn infant, a newborn child, do you have the capacity to even understand what consent is, what government is, what power or authority is? No, not remotely. Therefore, wherever you're born, you are not immediately made a subject, a slave, a resource, a piece of property to that government. Now, of course, the court's going to uphold that because that's another subject they get to supposedly exercise authority over. But in actuality, according to the principles of a free Republican government, according to the direct, explicit declarations of the founding generation, no, you being born is not a form of consent. Now, with your parents acting as your representative, if they give consent to being governed, acting as your representative by proxy, consent for you to be governed by the same laws. If they don't give consent, you can't give consent. You're a newborn child. You have no idea what consent is. So no, jus soli, spelled J-U-S-S-O-L-I, is not carried over into Western jurisprudence, is not carried over or affirmed at all by the founding generation. It's not in the U.S. Constitution, not even with the 14th Amendment, if you want to pretend like it was ratified constitutionally. It's not in the U.S. Constitution. It's not in the Articles of the Confederation. It's not in the U.S. Declaration of Independence. And here's a second point to this. So it's not in any of our governing documents because, one, you have to give consent for just powers of government to be exercised. But two, if there's going to be any body of government determining who is and who isn't a citizen of their state, it would be the states. Just like you can't be a citizen of a king or a subject of a state, you can't be a citizen or a subject of a union. Just like a king can't exercise authorities over a citizen, and just like a state doesn't have the extensive authority to call its residents subjects, you're also not a citizen or subject of a union. Now, you can be a citizen of your state and your state a member of a union, but you as an individual, you as a singular political unit, cannot be a citizen of a union. So if that question is going to be decided, it's going to be left to the states. Now, the Solicitor General, this is kind of a sub-argument to this point. The Solicitor General plays a little bit of theater when detailing the horrific tragedy of the Dred Scott decision, when in actuality, what Dred Scott decided wasn't a question of citizenship, but where the title of property belonged. And what Dred Scott ultimately decided, that U.S. Supreme Court case, what that decided was property belongs to whoever owns the title to that property, which could be a citizen, could be a state, could be a union. A union can have property, but it can't have citizens, and it can't have subjects. And this same argument plays into another cited case, another piece of precedence that was alluded to during the Trump versus Barbara oral arguments, which is United States versus Wong Kim Ark. Now, we can already throw this case out. Why? Because it's based on the false pretense that the 14th Amendment was ratified constitutionally. But let's just, for spits and giggles, entertain that it's a legitimate case. It says here, this is provided by oye.org, United States versus Wong Kim Ark, argued in 1897. Facts of the case: the Chinese Exclusion Acts denied citizenship to Chinese immigrants. Moreover, by treaty, no Chinese subject in the United States could become a naturalized citizen. No Chinese subject. Important note: you can be a subject to a dictator, you can't be a subject to a state. In the United States could become a naturalized citizen. Wong Kim Ark was born in San Francisco to parents who were both Chinese citizens, misuse of a term there, who resided in the United States at the time. At age 21, he returned to China to visit his parents who had previously resided in the United States for 20 years. When he returned to the United States, Wong was denied entry on the ground that he was not a citizen. So the supposed question is a child who was born in the United States to Chinese citizen parents, again, misuse of that term, parents who are lawful permanent residents of the United States, a U.S. citizen under the Citizenship Clause of the 14th Amendment. And the conclusion of the court came to, because Wong was born in the United States and his parents were not, quote, employed in any diplomatic or official capacity under the Emperor of China, which is bogus, anyone in China is a subject of the Chinese government, because the Chinese government ultimately has a dictator, whether they want to admit it or not, and you are a subject to that dictator. The Citizenship Clause of the 14th Amendment automatically makes him a U.S. citizen. No, because there's no such thing as a U.S. citizen. Again, you can't be a citizen. You can't be a subject of a union. If you can, congratulations, go ahead and publicly declare your United Nationite citizenship, since the U.S. is a member of the United Nations. Congratulations on your citizen of the globe acknowledgement or realization. Justice Horace Gray authored the opinion on behalf of a 6-2 majority. Please go read the two dissenting opinions, or the two in the dissent opinions. It's an interesting dissent, in which the court established the parameters, the concept known as jus soli, the citizenship of children born in the United States to non-citizens. Justice Joseph McKenna took no part in the consideration or decision of the case. So notice they had to establish it by legislating from the bench rather than what's in the U.S. Constitution. So another argument, third kind of a 3.5 or 3 subsection A argument, is both parties and the court in the Trump versus Barbara case, which you can see here. This transcript is publicly available online. What they alluded to, not just the English common law, they alluded to William Blackstone and Blackstone's commentaries. And if you're not familiar with Blackstone, he greatly influenced the founding generation's thinking whenever they went about constructing primarily the judiciary, but maybe more in general laws and the totality of a government structure. Now, what Blackstone says on this subject isn't exactly what is supposed and implied in the Trump versus Barbara transcript. Now, the court and both sides tried to imply that Blackstone supported this principle of jus soli, that supposedly by your birth you become an immediate subject, or you become not a subject, but you immediately become subject to any governing body, any governing authority that owns that land. Well, let's see what Blackstone actually says. Chapter 10 is where you can find this in Blackstone's commentaries, and it's titled, "Of the People, Whether Aliens, Denizens, or Natives." Now, I encourage all of you, go read this entire chapter for yourself. It's really not that long. I just want to skim through the most important parts so we can address all of these other important portions of what took place during the oral arguments. We're going to go ahead and skip past this allegiance section just because it's not super pertinent. It's not directly relevant. It has maybe parts here and there that are somewhat relevant to the arguments that were made, especially when the Solicitor General made this mistake of trying to conflate the words jurisdiction and allegiance, which is actually going to lead us into the now infamous Miss Jackson comparison or metaphor of being in Japan and stealing a wallet. So we're going to address that here in a second, but for the sake of time, we're going to skip past this allegiance section and go to one more pressing, one more relevant. He talks about natural allegiance. This would probably be the closest to what the Solicitor General was trying to imply. It says here, allegiance, both express and implied, is, however, distinguished by the law into two sorts of species. One natural, the other local. The former being also perpetual, so natural allegiance is perpetual, infinite, binding, infinitely binding. The latter, temporary, so local allegiance is temporary. Natural allegiance is such as is due from all men born within the king's dominions immediately upon their birth. For immediately upon their birth, they are under the king's protection. At a time, too, when during their infancy they are incapable of protecting themselves. So what does this sound like? Does this sound like the king immediately grabs power over you because of arbitrary reasons? No. It's because you are under the king's protection at a time that you are completely defenseless, so you're a newborn child. You have no other way of defending yourself. The king has a moral duty to protect you, to protect your life. They, the infant, are incapable of protecting themselves. Natural allegiance is therefore a debt of gratitude. So because upon your birth the king protected you, you are now in a contract which you did not consent to. This is one of those just blatantly clear reasons the founding generation didn't carry over principles like this, like Jus Sully. This contract that you've now made with the king, which you did not consent to, you are now naturally obligated to pay back. So because the king protected you in your infancy, though you didn't request the protection, because he devoted time and resources to you, you are now required to pay them back. Blackstone takes it just one step further. Natural allegiance is therefore a debt of gratitude, which cannot be forfeited, canceled, or altered by any change of time, place, or circumstance, nor by anything but by the united concurrence of the legislature. So not only are you to pay this debt back, but you're supposed to do it gratefully. Why? Because according to Blackstone, the king saved your life. Without his help, your infancy, your life, would have been ended very quickly. He says, further, an Englishman who removes to France or to China, so he's giving an example, owes the same allegiance to the King of England there as at home, in 20 years hence as well as now. What about local allegiance, the temporary allegiance? He says, local allegiance is such as is due from an alien or stranger born, for so long time as he continues within the king's dominion. So as long as you're here, you have to obey the laws. And again, this is in the context of a king. You're going to have to stretch almost to a point of unrecognition, applying or trying to argue that these same principles of king and subject, that relationship between king and subject, is even in any way remotely similar to state and citizen, to state and union. There is no similarity. Protection within the king's dominion and protection, and it ceases the instant such stranger transfers himself from this kingdom to another. Natural allegiance is therefore perpetual, local, temporary only, and that for this reason evidently founded upon the nature of government, that allegiance is a debt due from the subject upon an implied contract with the prince, that so long as the one affords protection, so long the other will demean himself faithfully. So as long as you depend upon the king's protection, the prince's protection, the monarch's protection, you are thereby indebted, even as a newborn child, to serve that king, to serve that monarch, so you can repay that debt or pay back that debt. As therefore the prince is always under a constant tie to protect his natural-born subjects at all times and in all countries, for this reason their allegiance due to him is equally universal and permanent. Now here's the part that I'm sure everybody involved in this Trump v. Barba issue is going to try to avoid. They quote Blackstone, they allude to Blackstone, they say, yep, Blackstone definitely supported this idea of jus soli. Well, if you're going to apply those principles of Blackstone and bastardize his ideas, make sure not to cherry pick, make sure not to nitpick, because even though I guarantee you're not going to like this section, it's another set of principles that he upheld. Rights of aliens. An alien born may purchase lands or other estates, but not for his own use, for the king is thereupon entitled to them. Yet an alien may acquire a property in goods, money, and other personal estate, or may hire a house for his habitation. A personal estate is of a transitory and movable nature, and besides, this indulgence to strangers is necessary for the advancement of trade. Aliens also may trade as freely as other people. Also, an alien may bring an action concerning personal property and may make a will and dispose of his personal estate. When I mention these rights of an alien, buckle yourselves up. I must be understood of alien friends only, or such whose countries are in peace with ours, for alien enemies have no rights, no privileges, unless by the king's special favor during the time of war. So is this a carte blanche permission? Anyone born on state soil, anyone born on U.S. soil, anyone born within these United States is thereby granted all rights, privileges, and protections. They are granted immediate citizenship? No. Alien friends only. And he reiterates this in the last paragraph of this section. He says, the children of aliens born here in England, so on England's soil, are generally speaking, not always speaking, not every single instance speaking, generally speaking, natural-born subjects and entitled to all the privileges of such. But I'm sure the court and both attorneys are going to conveniently leave those parts out. They're going to leave out this, whatever an alien purchases, land or other estate, is actually entitled to the Union government. They're also going to leave out this generality but not universality of protection to the supposed natural-born subjects. They're not going to apply that. They're only going to apply and nitpick the areas that they bastardized and are trying to argue support this idea of jus soli in a Republican form of government. So now, before we get to the infamous quote by Miss Jackson about stealing a wallet in Japan and that supposedly being allegiance to obey the laws of Japan, I want to reiterate this very key important point. Consent of being governed. Does that mean if you don't consent, you can then go to any sort of government, you can go to any sort of land, any sort of territory, and do whatever you please without consenting to the governed? No, because those governments also do have authority over the citizens with which they've made a compact. They've promised, specifically in the U.S. context, that if and when the citizens say, hey, there's something wrong going on here, there's something illegal, there's an invasion, an insurrection, there's criminal behavior going on here, that government has a duty to those citizens, because of what they promised in those contracts, to go and act against whoever is causing the nuisance, whoever is causing the disruption of peace. So with this consent of governed principle, it's not a permission slip for anybody to go and do whatever they wish, strangers of foreign nations to come here, not consent to being governed and then acting however they please, because there is still a government. And that government, in a contract with the citizens, guarantees to the citizens that the laws which the citizens implement, as long as they're constitutional, will be enforced. They'll be enforced by the governing body, and they will accept that duty as the governing body of enforcing those laws so that the citizens don't have to worry about it. Now, if the governing body doesn't do that, then that power then returns to the citizens, and of course the citizens have to go about doing what they naturally would have to do if that governing body didn't exist. So no, consent to be governed is not an anarchical principle. It is one that returns to the individual what is stolen in the subject to king relationship, the subject to monarch relationship. It is what's almost perfectly stated in the Texas Constitution, Article 1, Section 2, political power, all political power is inherently in the people. The people ultimately determine how the government is going to be run. And anyone within that land, anyone within the political boundaries of that government, acting in discordance to the laws that the people determine to be enforceable, is violating that contract, is disobeying that government, which was ultimately determined by the people. So by proxy, they are acting against the people, which is why in criminal cases, whenever the district attorney brings up charges, it's the people of the state of Texas do hereby charge against or accuse such and such of these crimes. The DA, the government, is supposed to be the enforcement arm of the citizens. That's what consent of the governed means. It's not an anarchical principle. Okay, so now we can get into the fun part of Miss Jackson's wallet metaphor, whatnot. So she brings up this idea, and of course Miss Wang immediately agrees that it's a perfect metaphor. It's not remotely a perfect metaphor. It was ridiculous for the Solicitor General to try to conflate the words allegiance and jurisdiction to mean similar things. They don't. Allegiance is, as explained by Blackstone, subjection to a governing authority. Jurisdiction is the governing authority exercising authority over you, exercising power over you. Those two things are different because jurisdiction has to, at least in the Western context, be first constitutional, while allegiance is, like the relationship between a king and subject, can be implicit, can be later determined, can be expansive. Jurisdiction and allegiance, two very legally different terms. So it was very silly for the Solicitor General to try to conflate those terms. But in response to this, Miss Jackson tries to apply this standard that the Solicitor General is proposing, and she says, and I was thinking, you know, I, a U.S. citizen, am visiting Japan, and what it means is that, you know, if I steal someone's wallet in Japan, the Japanese authorities can arrest me and prosecute me. It's allegiance, meaning can they control you as a matter of law? I can also rely on them if my wallet is stolen to, you know, under Japanese law, go and prosecute the person who has stolen it. So there's this relationship based on, even though I'm a temporary traveler, I'm just on vacation in Japan. I'm still locally owing allegiance in that sense. Is that the right way to think about it? And if so, doesn't that explain why both temporary residents and undocumented people would have that kind of allegiance just by virtue of being in the United States? And Miss Wang, representing Barbara, says, that's absolutely right, Justice Jackson, and that comports with the plain text of the 14th Amendment as it applies to everyone born in the United States. That needs to say these United States. Other than those subject to the exceptions that were baked in, a closed set, you owe natural allegiance as a U.S.-born citizen. Natural allegiance. That's different from what Jackson is trying to say with local allegiance. And we just went over those two differences in Blackstone's commentaries. So no, Miss Wang, that's not absolutely right, because you're talking about natural allegiance, which is perpetual, infinite and unchanging, which is directly contrary to the consent of the governed, and Miss Jackson is trying to apply this idea of local allegiance, which Blackstone said, actually, the moment, what was it that he said? Let's go back to local allegiance just real quickly. So rights of aliens, by the way, rights of aliens, local allegiance, natural allegiance applies generally, not universally. Local allegiance, he says, is such as is due from an alien or stranger born for so long time as he continues within the king's dominion and protection, and it ceases the instant such stranger transfers himself from this kingdom to another. Natural allegiance is therefore perpetual and local temporary only, and that for this reason, evidently founded upon the nature of government, that allegiance is a debt due from the subject upon an implied contract with the prince, so that so long as the one affords protection, so long the other will demean himself faithfully, as therefore the prince is always under yada yada yada. So they are talking about two completely different types of allegiance. But let's go over how, very quickly, how silly this metaphor is and why it should be mocked. So Jackson is saying she's a US citizen in Japan, which would make her a foreigner. He's trying to argue that she owes local allegiance to Japan because she's a traveler. There is no allegiance, there is no legent relationship between Jackson as a U.S. citizen, which is an oxymoron, you can't be a citizen of a union, as a foreigner in Japan. There is no legent relationship. The only relationship of allegiance is between Japan and the Japanese, which means when a foreigner comes in and commits a crime, such as stealing someone's wallet, you being punished, the thief being punished, a foreigner being punished, is not you upholding the Japanese law. Rather, it's the Japanese government upholding its allegiance, upholding the promise it made with the Japanese citizens. You stealing the wallet is not showing allegiance. You not stealing the wallet is not showing allegiance. Because trying to say that that's local allegiance isn't complying with what Blackstone is saying here. Now, if you have a different definition of local allegiance, let's go ahead and hear that and we'll consider that. But if you're going to try to allude to Blackstone and use his standards, you failed. Because you, as a foreigner, don't have a legent relationship with the Japanese government. So we'll go ahead and summarize 3 or 4 main points. First and foremost, this entire case falls flat because the 14th Amendment, which both sides are depending upon for their arguments, was never constitutionally ratified. And now, hopefully, because of this case, we can see why it was never constitutionally ratified, why the states refused to ratify it, and why even those who were in favor of something similar to it, why even those states didn't even ratify the 14th Amendment. It is horrifically worded. It is terribly not even misunderstood. It's just a terrible proposal. It's terrible law. It's terrible legislation, and it tries to completely rework the relationship between citizen and state, state and union. You can't do that in a Republican form of government. Now, if you want to go and try to suppose the U.S. Constitution somehow upholds both a Republican form of government and a king-subject relationship, go ahead, but you're going to have to stretch to the limits of unrecognizability or of unrecognition. Point being, the 14th Amendment was never constitutionally ratified, therefore, this entire case just falls flat because both sides have no constitutional basis to found their arguments. Second, the 17 allusions to English common law, no matter how many times you allude to it, is not authoritative. It's not even persuasive because, one, we left English common law. We threw it out the window whenever the Continental Congress adopted the U.S. Declaration of Independence, sent it off to the Crown. And second, the author you allude to for that basis standard of English common law doesn't even agree or endorse the ideas that you're trying to purport and suggest he supported, suggest that he in any way provided a foundation for. So not only is English common law non-binding in Western jurisprudence, but the individual they alluded to for that basis of English common law doesn't support what they're trying to suggest he supported. Third, jus soli, another key point that both sides are relying on. Well, the Solicitor General is trying to apply what's called jus sanguinis, which is Jus Sanguinis. Jus sanguinis means jurisdiction by blood. So if your parents are official citizens of a state, then you being born to those parents makes you a citizen. Jus solis was not affirmed by the founding generation, which is why they didn't include anything similar to the 14th Amendment in the U.S. Constitution. Further than that, if that was to be a question decided, it would be left to the states, because you can't be a citizen of the Union. You can only be a citizen of your state, and your state can be a member of the Union. Third point on that subject, in the U.S. Declaration of Independence, it says overtly, the founding generation overtly declared that the just powers of government, like jurisdiction, are derived from the consent of the governed. Being born is not a form of consent. And lastly, when it comes to, we can probably wrap this up with Jackson's wallet metaphor. When you go abroad and you're a foreigner in a land that is under a different government, you are not showing allegiance to that government by obeying their laws. Or you're conforming with what their people have decided to be their government. But you're not showing allegiance, local or natural, at least in terms as Blackstone defined them. So because Miss Jackson actually couldn't give a proper comparison or a proper hypothetical for this question, I'll go ahead and provide one that is one-for-one identical to this situation that Miss Wang is trying to suppose. If there's an emergency, pregnant woman, it's too dangerous to deliver the child in a car, not enough time to get to the hospital. They pull over to the side of the road, knock on the nearest door, and ask if the resident would let them use their home to birth and deliver this child. Upon that child's birth, which, that sounds kind of odd, but it happened pretty frequently in older days. Upon that child's birth, does that homeowner now have authority over that child? Does that child adopt the last name of the homeowner? Because if we apply jus soli, he would. That child would become a member of that homeowner's family. See, when we apply that, that's the requisite, necessary conclusion of jus soli. Whenever we apply that standard and try to mesh it with a consent of the governed mentality, it doesn't work, which is exactly why anything like the 14th Amendment was included or was ever advocated by the founding generation when the U.S. Constitution was being debated and ultimately got implemented. So, Miss Jackson, instead of your irrelevant wallet comparison, irrelevant wallet metaphor, use that one and answer that question. If a stranger's child is born in a random house, does that child now belong to the homeowner? Does that child now adopt the last name of that homeowner? Does that child in any way have a debt to pay, as Blackstone would have suggested, a debt to pay to that homeowner? Answer that question rather than the irrelevant visiting Japan wallet getting stolen question. And what this should also show with the 17 allusions to English common law is just how insufficient, deficient, or maybe even malicious the legal education standard required by the American Bar Association is, which is why the Calhoun School of Law, or a significant part as to why the Calhoun School of Law was formed and why we are so happily, self-declaredly, not accredited by the American Bar Association. Because look at what they produce. The Solicitor General, Ms. Wang, and all 9 judges on the U.S. Supreme Court assume the 14th Amendment was ratified constitutionally, and second, that this jus soli English common law in any way is binding, constitutional, or authoritative. They cite to that more than they cite to the U.S. Constitution. So in summary, the reason we believe the U.S. Supreme Court is going to side with Miss Wang, with Barbara in the cause, is because Solicitor General 1 is basing his argument on the 14th Amendment, which was never constitutionally ratified, thus it's not constitutionally binding, and 2 tries to argue that allegiance and jurisdiction are remotely related. And then as a subpoint to that, he alludes to Dred Scott and the supposed tragedy of the Dred Scott decision, so on, so forth. What he's asking the court to do is something that he may even lose Thomas and Alito on. He's asking the U.S. Supreme Court to apply what the 14th Amendment was supposed to do rather than what it says. And it's because of what the 14th Amendment says that the state legislatures did not ratify it. It's horrible law, it's horrible legislation, and it was never constitutionally ratified because it's horrible law, because it's horrible legislation. He is asking the court to apply the 14th Amendment as it was supposed to be applied rather than how it's written. Now, in terms for the entire case, both sides and the court, 1, English common law is non-binding. Stop alluding to it. Stop trying to use it as precedence. We left that with the Continental Congress, with the U.S. Declaration of Independence. 2, jus soli does not apply here because, again, jus soli applies when you have a king and subject relationship, not a citizen and state relationship. Not when you're in a free republican form of government that requires consent from the individual in order for just powers of a government to be exercised on that individual. You cannot have perpetual, immediate subjection upon your birth and consent of governed at the exact same time. They are diametrically opposed principles, which is exactly why the founding generation didn't carry over into Western jurisprudence this idea of jus soli. They didn't even carry over jus sanguinis, because again, if that was a question to be answered, it would have been left to the states. So the question becomes, okay, what can we do when this likely outcome comes about? Well, we do what Thomas Jefferson and James Madison both declared in the Kentucky and Virginia resolutions of 1798. Thankfully, as Alexander Hamilton explained, the judiciary is the least threatening to the liberties, the rights of first the citizens of the states and the powers of the state governments. So whenever this probabilistic opinion comes out that the states have to facilitate and permit invasions of their states via births of foreigners on state soil, whenever this opinion comes out, the proper response is to say, no, actually the U.S. Constitution doesn't provide for that. And instead of the U.S. government thinking they get to determine on behalf of the states who is and who isn't a citizen of those states, the states are going to determine, as they've always had the power to determine, who is and who isn't a citizen of their state. In short, the states and the citizens therein will have to tell the U.S. Supreme Court no and nullify, render moot the likely unconstitutional, ahistorical, illegitimate ruling will likely come about in Trump versus Barbara, which will suppose that, yes, birthright citizenship, including to those of foreigners just temporarily visiting, including those individuals, has to be protected, is legitimate, is constitutional, and thus makes those newborn infants citizens of those said states. So, if you have any questions about what was said here, if you think I'm totally off my rocker, or if you would like me to maybe do a live stream, something like that, where we actually listen to the oral arguments that were made Go ahead and let me know down in the comments, because the entire purpose of the Calhoun School of Law is to equip you with the necessary skills and information such as this to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope y'all have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.